Good evening, ladies and gentlemen. My name is Angelo Rafael, and I have the honor of introducing here today the guest speaker, Professor Marcelo Carvalho Loureiro. I saw there also MC Loureiro, who came all the way from the UK to be with us tonight. Professor Loureiro is an assistant professor of law at the University of Leicester. He is a socio-legal theorist interested in the colonial and post-colonial aspects of citizenship law and belonging. Tonight's talk is titled Colonial Citizenship, the Macau Route, and is based on his book currently in press titled Colonial Citizenship, Law, Race and Rights Through the Portuguese Empire. This book is the first comprehensive legal study on citizenship, race and rights in the Portuguese Empire, including Macau. Drawing on German status theory, I hope I pronounced correctly, and new archival material, it traces how colonial law organized belonging, indigeneity, and assimilation from the 15th century to the present, arguing that Portuguese coloniality still structures nationality, citizenship, and access to rights in the post-colonial present. So I will leave the floor to Professor Loureiro to give his talk. A round of applause for him.
Thank you very much. Thank you very much, Angelo. So what I'll try to do today is basically a presentation of the book together with the exposition of how colonial citizenship finds expression in Macau. The book's quite long, it has around 500 pages, so I'll do my best to be as quick as possible, to cover as much as possible, without not becoming unintelligible. So, I think the first thing that is important to comprehend is how this is going to work today. So we have basically three parts. The first is an introductory part where I talk about the colonial order and how it was organized throughout the Portuguese Empire. The second part is mainly based on how citizenship, race and indigeneity developed throughout the Portuguese Empire. And last is basically a contextualization with Macau. In the book, I call Macau the last colony. And Macau has a structural importance in understanding how citizenship worked in empire and what was the role of citizenship during and even after empire. I think it's my beard, I'm sorry. So everything that is in orange borders is exclusive to the book or has been used in the book for the first time, academically speaking. And I'm glad to take questions either in Portuguese or English towards the end. So, thinking about the Portuguese Empire is thinking about more than 500 years of colonial history. Thinking about the Portuguese Empire is basically starting in 1415 and ending in 1999. So we have more than half a millennium of history, half a millennium of territories, half a millennium of contact with people, with communities throughout the whole globe. Many times the Portuguese Empire has been termed the first and the last modern European empire. And that's very true. The Portuguese Empire stretches from the beginning to the end of modernity. It's the only empire to have done so. Not even the English, not even the Germans, the French, the Spanish, none of other European empires stretched as long as the Portuguese Empire did in terms of historical periods. So the Portuguese study case is extremely important to understand how citizenship worked. I dare to say that it's the key case to understand how citizenship works nowadays. So this is just an exhibition of the many colonies Portugal had, and pay attention, I normally talk with English audience, a British audience, so this is necessary in general, but here not very much so. But it's just a way to contextualize and to give a little bit of an idea of the spectrum of Portuguese colonialism that stretched throughout many, many, many centuries. There you can see a shoemaking workshop in Xeringoma, Mozambique, dating from 1933. The picture belongs to the Companhia de Mozambique, which I thought was defunct, but actually they still have a surviving body in Kent in the UK, so they hold the rights for the picture. This is just as a way for us to understand a little bit how empire worked in terms of constitutional organization. When we think that all the colonies were the same, we're thinking wrong. We need to understand that there were different kinds of colonies, different kinds of colonial territories that spread across the Portuguese globe. And it's important for us to notice that when you're thinking about citizenship, we ought to differentiate between non-indigeneity colonies and indigeneity rule colonies. When you're thinking about non-indigeneity colonies, we're thinking mainly about Macau, India, and Cape Verde. Those three colonial territories, they were not under indigenato, they were not under indigeneity rule, basically meaning that people that were connected, born in those three places, they were citizens. They were not considered indigents. They were not considered natives from a legal point of view. On the other hand, when we think about Timor, Angola, Mozambique, Guinea, and São Tomé and Príncipe, everybody that were connected, constitutionally speaking, in terms of citizenship, in terms of nationality, to those territories, they were considered indigents. Timor and São Tomé and Príncipe later on were deleted, if we can say, from the indigeneity rule, but Angola, Mozambique, and Angola, Mozambique, and Guinea continued being indigeneity colonies until the end of indigenato, until the end of indigeneity rule. And this will become clearer towards the end. So, non-indigeneity colonies, Macau, India, and Cape Verde. Indigeneity colonies, Timor, Angola, Mozambique, Guinea, and to a certain extent, São Tomé and Príncipe. When we're trying to understand, and I say trying because it is very complicated, it is very confusing, and I think it was the part of the book that took me longer to understand, we need to pay attention to how the Portuguese state was organized, especially during the early 1900s. Of course, we know that everything that happened before the Colonial Act and with the dictatorship and so on, but this period is fundamental for us to be able to grasp, to comprehend, to understand, even very slightly, because it is very confusing indeed, how the Portuguese state organized itself during this period. So, until the 1930s, the Portuguese state was mainly what we can call a complex unitary order, meaning that the Portuguese state would be ruled mainly centrally by Lisbon. They would issue different genres of law, like regiments, administration bills, leis orgânicas, and even sometimes force the colonies to issue provincial charters. So this is to say that before the 1930s, the organization of the colonial state, if we may say so, was very complex, and it used at the same time centrally enacted legislation and locally enacted legislation that sometimes would not be very clear in the sense of what they were imposing or establishing. This definitely changed by the 1930s. By the 1930s, we can definitely say that the Portuguese state was organized in two constitutional orders, not one, two different and separate constitutional orders: the Metropolitan Constitutional Order and the Colonial Constitutional Order. The Metropolitan Constitutional Order was ruled by the Portuguese Constitution, and the colonies, they were ruled by the Colonial Act. It was as simply as that. The colonies had a constitution for themselves, the Colonial Act, and the metropole had a constitution for itself, the proper constitution itself. This is fundamental for us to understand that when thinking about colonial law, we're thinking about the law of difference. Colonial law is always the law of difference, meaning in constitutional terms organizing the state itself, but also in terms of citizenship, organizing who belongs to each of those orders. So there we can see examples of people belonging to those different constitutional orders. The first picture is my great-great-grandfather, Henrique Batista, and comes from a family archive, and he was definitely considered a citizen back then. But the picture at the bottom is from a photography book called Guiné Portuguesa from 1943, and the photographer is Amandio Lopes, and it portrays a tribal leader in former Portuguese Guinea, and he was not considered a citizen, but an indigent. And in practical terms, we will look at what meant to be an indigent during the Portuguese Empire. But I think that what is fundamental for us to understand before that is that there was a division between the colonial and the constitutional order. and this will become clear in subjective terms, meaning how it mirrored in everybody's life later on. So when you think of metropolitan order, we think about citizenship, we think about citizens, and when you think about the colonial order, we mainly think about indigents. There were three exceptions, though, like I mentioned at the beginning, to this indigeneity being applied in the colonial order. And they were the people connected to Macau, India, or Cape Verde. I will not have time to go over the situation of India and Cape Verde today because it would be very difficult. But we will go over the question of Macau. That's why I'm here. And this will become clear towards the end why Macau is so important to understand not only the aspect and the conceptual broadness of citizenship, but also its practice, its everyday practice. So now we start part two. And part two is basically a means to connect Macau as a context, as an application, as an understanding of how citizenship works in practice, and this more theoretical idea of two separate, segregated, if you may, constitutional orders. So when you think about Portuguese citizenship, we need to go back to the Iberian Union. Iberian Union is not a period that has been studied broadly in legal terms. When you start studying Portuguese citizenship law, you normally find mentions of Iberian Union here and there, but it's very difficult to actually find the true connection. How did Portuguese citizenship law emerged? How did Portuguese citizenship law actually was created? And Portuguese citizenship law was created by a transposition from Spanish law into Portuguese law during the period of the Iberian Union. So we can say that to a certain extent, Portuguese citizenship law comes from a para-coloniality with Spain. When Spain was not necessarily colonizing Portugal, was definitely dominating it. So in 1603 is the first time that Portugal gains, if we may say, a constitutional a citizenship clause. And you can have a look at the translated version right here. Later on, the citizenship clause that mixed both jus soli and jus sanguinis aspects of attachment to nationality was transmutated to the civil code, and in 1867, but before was part of the Portuguese constitutions of 22, 26, and 1838, always using a mixed jus soli and jus sanguinis approach. So whenever you hear that Portugal always used a jus sanguinis approach, that is not only wrong, it's a lie. Here we meet a theoretical part that I just included for the sake of clarity. Whenever we think about citizenship, we're thinking more about the material aspect of rights. When you're thinking about a formal attachment to citizenship and a formal attachment to the state, we're thinking about nationality. And people that might be acquainted with French or other legal systems might understand this very quickly. When you're thinking about a formal attachment to the state, the adequate term to use is, in general, nationality. Nationality means a formal attachment to the state. It means that you're able to have access to a passport, to an identification means, to a card. But citizenship, on the other hand, translates the idea of a material access to rights, a material notion of belonging. And that's part of the book too. That's one of the novelties that I was able to bring by reinterpreting German status theory. And it's only a means for us to understand that when you're thinking about nationality, when you think about citizenship, there are different levels to it. We cannot say from a subjective point of view that everybody lives or has the same kind of attachment to the state. We should always be able to interpret it from a subjective point of view. And what I tried to establish with the book is how to do that. How can we see someone's specific constitutional citizenship situation and place it within a map that actually dictates and or is able to indicate where this person belongs within this big spectrum? Because you might agree or disagree with me, but in general, someone that has a formal attachment to the state and live in a favela, and someone that has a formal attachment to the state and live in a luxury building, they do not occupy the same citizenship point. They do not occupy the same citizenship spectrum, point in the spectrum. They occupy different points in that same spectrum. These are only the different kinds. I will not go through them, but you have access to them in the presentation. Just in case you want to read further, They're also part of the book. That's already at the introduction. I won't be able to go through them specifically because the focus will be on Macau, but I wanted to include them just for the sake of the ones at home or the ones that would be interested in having a look at it later. So just to summarize, the way I think about citizenship is that it's formed by both a formal and a material dimension, and that the role of the legal system should be to push toward justice of rights. So the role of citizenship is to fulfill a justice of rights role, is to fulfill a role that will make citizenship accessible to everybody that has a claim to rights, and that those people should be able to access rights in their material dimension, not only by the letter of the law, not only formally. And that is the approach that I take to citizenship from a political theory point of view. So, let me just have a little bit of water because I'm talking a lot. So, we already understood that when thinking about citizenship in the Portuguese Empire, when thinking about belonging in the Portuguese Empire, we had these two zones of belonging, a citizenship zone and an indigeneity zone. So when thinking about indigents, who were indigents? How did Portuguese law establish who were indigents? So the Indigent Statute of 1926 goes like this. For the purpose of this statute shall be regarded as indigents all individuals of the black race, and I quote, or their descendants, who by their level of education and customs do not distinguish themselves from the general population of that race. Basically, an assimilation clause. Basically, a clause about civilization. A clause that attaches race to being able to claim or rights or being forced to occupy a specific subaltern position in the state. So what I say is that the Indigent Statute used a racialized means to impose a subnationality on people of color in Angola, Guinea-Bissau, Mozambique, but also Timor. Timor is generally forgotten when you think about indigeneity, and the reason for it is because Marcelo Caetano and other theorists of the colonial state tended to say that Timor did not apply indigeneity overtly, but it did. And in the book, I found around 5 or 6 ordinances, so provincial legislation, that not only imposed but forced people to pay indigeneity tax and to sometimes be interned in indigent schools. So with the book, I also go back to these very classical fathers of the colonial state, and I'm able to establish that there was indeed an imposition of indigeneity in Timor, but Timor is not the case in analysis today. So basically, you were an indigent if you could not fulfill requirements for language, livelihood, civilization, and economic capacity. If you could not prove that you were sufficiently connected to the colonial state, then you would be deemed as an indigent. And this meant that you would live a life of restrictions. This meant that you'd live a life where rights would not even be part of your subjective sphere. It would be outside of the possibility for you to have rights. And we'll get to that very soon. Another interesting and necessary aspect is to think about the eras in the Portuguese indigeneity rule. I established 4 different periods. People tend to establish just 2, but I decided to put them into 4 because it's fundamental that we divide between the early statutory period and the late statutory period, as I will explain. So the first period is the introduction period. This introduction period, when you think about indigeneity, when you think about the imposition of a racialized subnationality, basically used central government laws. So they were the decree on sentencing indigents, the regiment for overseas justice administration, the indigent work regulation, and the overseas provinces administration bill of 1914. So those laws range from 1894, around the late 19th century, until the 1915, the mid 1910s. And they basically introduced indigeneity as a legal matter, introduced indigeneity as a clause that would then appear throughout the whole Portuguese colonial system. So after the introduction period, we have the consolidation period. The consolidation period mainly used provincial laws, mainly used what what used to be called provincial charters. Those provincial charters, or cartas orgânicas, they were issued by every colony but Mozambique. Mozambique did not have, was not able to issue a provincial charter because of internal political matters, but all the other colonies, they issued provincial charters, either acknowledging and applying indigeneity or refusing it, okay? So when you think about all the colonies, Angola, Guinea, and Timor, as well as São Tomé and Príncipe, to a certain extent imposed indigeneity, okay? Angola very clearly, Guinea as well, and Timor too, but São Tomé and Príncipe indirectly. São Tomé and Príncipe imposed indigeneity only to the people of color who would come from other colonies and serve as laborers in the plantations. Towards the end, it becomes a little bit unclear if the provincial government was forcing people that were from São Tomé and Príncipe to be to have indigeneity imposed onto them, but that's still something to be established. I discuss it in the book a little bit, but the Batepa War that led to São Tomé and Príncipe to have indigeneity clearly revoked is one of the signs that the government tried indeed to impose indigeneity on people that initially were not supposed to be deemed legally as indigenous. Cape Verde clearly denied indigeneity being imposed in the territory, as well as Macau and India. But the way India denied it was by specifically and clearly establishing that indigeneity was not applied in territory, whilst Cape Verde and Macau only did not mention indigeneity at all. Then we have the early statutory period. The early statutory period was marked by the first indigent statute of 1926 that then gained a new version in 1929. It was very similar. It was mainly for administrative and organizational purposes. So the clauses are very, very similar in term, in language, and also in requirements. But also the Colonial Administration Act of 26, the Indigenous Work Code of 28, and the Colonial Act of 33. They established the core of the statutory period that would then be revised and amplified in their imposition of indigeneity during the late statutory period. The late statutory period is the shorter of all of them, but it's definitely the most important. It is in the late statutory period that indigeneity becomes a global marker of subalternity. With the Ordinance of 1955, the Portuguese central government imposes that indigeneity would not be applied only in Angola, Guinea, and Mozambique, but also in the metropole or anywhere in the Portuguese world an indigent would find themselves. This created very precarious right situations for many people that would be living outside of continental Africa for many years, but we'll get to it very soon. So those are the main periods that that we need to look at in order to understand citizenship, race, and indigeneity in the Portuguese Empire. In the book, I go through them specifically. Each of them has specific sections in the book, but a summary. I just try to provide a summary as clear as possible, and in the amount of time that we have. And you might ask me, okay, we understand sometimes the law and reality, they do not match very well. But in my research, I came across this quote from Marvin Harris that wrote in 1958, in Mozambique, European-only notices are not needed in order to maintain an almost perfect separation between African masters and the Europeans. For example, a bus ride in Lourenço Marques costs the equivalent of 1/4 of the average African's wage. So when you do not need a clear segregation system when the segregation is embedded not only in the practice of social rights, but also in the way citizenship itself is created. And was indigeneity segregation? Can we say that indigeneity is segregation? Can we affirm today that the Portuguese Empire used segregation laws in order to maintain a white and a non-white legal order? My answer is yes. My answer is yes because of many different rules, many different ordinances, many different pieces of legislation that I was able to find during archival work. I don't think I will have time to go over all of them, but indigents were imposed different level of restrictions. The restrictions in the book, I classified them in 3 different levels or 3 different types. We can think about ontological restrictions or restrictions in being, basically imposing a sub-personality, a sub-legal persona on the indigent. For instance, no voting, no freedom of religion, no right to property, no right to migrate or change residence, depending on the colony we're talking about. So those were the fundamental restrictions imposed on indigents. That's what I call ontological restrictions. Then we had relational restrictions that prohibited some accesses or made life harder for the indigent. For instance, no access to public education, generally only missionary education depending on the colony, forced labor instead of imprisonment. So forced labor was the general penalty imposed on indigents but not on white people. No right to lawyers, so indigents did not have right to lawyers when they were being persecuted criminally, and they also had a separated judicial system. Those would be the second layer of the constitutional restrictions imposed on indigents. And then we'd had maybe the most perverse of them, the extractive restrictions. For instance, the imposition of capitation taxes, no freedom of labor, need to work for free for the state. Those are just some examples of the genres of restrictions that would be imposed on indigents. I go over them, I develop on them comprehensively in the book. But today I decided to bring a couple of them. I won't be able to talk about all of them, but for me, the starker of all of them, the more perverse of all of them, is the radio tax that was imposed in Mozambique from '56. Radio tax was imposed on indigents who owned radios. You'd have to pay annually a fee for the state for owning a radio if you were an indigent. The reasoning behind it, if you could listen to the radio, if you could hear the radio, if you could hear Portuguese, you would be able to fulfill one of the requirements to become a Portuguese citizen, and you should pay for it. Other taxes, for instance, included tax on residence change. That's another way that I was able to refute the argument that indigeneity was not applied extensively in Timor. There is a law from 1923 that establishes a resident change tax in Timor. For instance, in Timor, circulation between the circumscriptions, between the municipal orders, was not forbidden. But every time an indigent would like to change from one freguesia to another, from one area to another, they had to pay a specific tax. And I'll just mention this one because I think this one is the one that I was able to locate first, which is the use of mandatory metal plaques for identification in Mozambique from 1913. And for me, together with the use of collars in Guinea, specifically in the islands, in the Bisagos archipelago in Guinea from 1913, if I'm not mistaken, they form what I call corporeal ways of restrictions. So ways that restrictions existed in the bodies of people by having to use a plaque with your number to identify that you were an indigent. So what I established in the book, what I support in the book and throughout my research, is that indeed there was a segregated nationality, that there was a division that was created not only legally but also in the real lives of people that had to live under indigeneity. And the only way for you to get out of it was by assimilating. Assimilating was a way to prove to the state that you were civilized enough, sufficiently Portuguese in order to leave indigeneity and enter citizenship. In general, and that is the most developed assimilation clause of all of colonial law, they established a legal age, also be able to speak Portuguese correctly. In some provinces at some periods, they also established that you could speak any civilized language. So French, Spanish, English would also be accepted. You had to exercise a profession. You had to have good conduct and not normally be a draft evader. So you had to fulfill your military duties. So those would be the requirements: language, civilization requirement, behavior, which would include also being not being behind with military duties. My approach to citizenship is one that is based on a subjective notion of belonging, and this notion of belonging comes from Jörg Jelinek, a German legal theorist, that not only created a typological means to understand what a state is, but also created a typological way to understand what a citizen is. And I draw on his theory to think about the two formal and material aspects of citizenship, but those two together, those two aspects together, the formal and the material, they subsist, they exist in a body, they exist subjectively in a person, right? And during my research, I always felt this need to be able to tell law through the stories of the people that once had no voice. And I always liked archives, I always liked history, I always liked to be able to look at the past in the present through those means, through those materials. And I was doing my fieldwork in Lisbon at the Arquivo Histórico Ultramarino, and I knew that there was a law from 1955, like I mentioned, that globalized indigeneity, that made indigeneity global. And I asked at the archives, where are those applications? Do we have access to the post-1955 applications? And they said, we don't have them. I couldn't believe it. I knew that they had it. I knew someone in Lisbon during the 1950s had faced this imposition of living there, and despite that having a law from 1955, bringing them back to indigeneity, forcing indigeneity onto them despite being residents in the metropole. And I was right. After 3 days going there and requesting this vehemently to the lady of the archives, I was able to talk with one of the directors, who was super helpful and a very kind person, and told me, tomorrow you come back, we'll see if you have anything. They had to ask the person who was in charge of the cleaning of the archives if the person knew if there was any boxes with that content, and the person took 3 minutes to find it. And this just tells us that sometimes we go to the wrong places to ask questions to. That person that was there for many years was able to find them, and they were like, I'm not too sure if that's what you need, but those 3 boxes, they have been lying around for many decades, and we don't know exactly what's inside them. So all the documentation that is here and is going to be published in the book, they are not indexed. They were not indexed by the archives because they didn't know they existed. And in the 3 boxes, I found 11 applications from 11 different men and women. And those applications, they served as the spine of the book, as the subjective spine of the book, where I tried to go through their stories to understand how coloniality and how citizenship worked subjectively in the Portuguese Empire. And I think it's important that I mention their names: João Rodrigues, João von Dunen, João Batista, Arthur, Carlos, Julião, Joaquim, Maria, José, Cecília, and Fernando, who were victims of the Portuguese Empire during its starkest period. So I'll tell just the stories of a couple of them, the stories of the ones that marked me the most. José Brás was from Angola. He was illiterate, so he could not read, he could not write, but he could speak Portuguese. He had been living in the metropole for many years, but then the 1955 law was issued, and he lost the citizenship he had before. Because the way the law worked was indigeneity would be applied in the whole empire, and those people living in the metropole, they would enjoy practical assimilation once they stepped into European civilization. And that's how the prosecution services framed this automatic gaining of citizenship. But from 55, this automatic gaining was stopped, and people that were living in Lisbon had to apply for it despite having been living there for many years. And that was the case of José Brás. He was baptized only in his 30s in Angola, and he used this baptism certificate in order to claim citizenship, and his citizenship got approved. We also have Maria da Gloria. Maria da Gloria, the reason why she claimed that she applied for citizenship, for assimilation, was because she wanted to study, and indigents were not able to progress into all the levels in school. So she had to assimilate in order to be able to finish school. And her father was not assimilated, so she could not claim citizenship based on the father. She was just a teenager, so she was not independent. So theoretically, she did not have the right to be a citizen. And that's one of the ideas that I bring in the book, which is, in her case, she was only able to claim citizenship. She was only able to get citizenship because someone within the administration turned a blind eye and gave it to her. And I think that those people, the people that issue visa for the persecuted, the people that hide people in the basements, the people that sign off papers, giving people's rights and protecting them, they also play a very important role in this whole machine against perversity. And Maria da Gloria, she actually was able to enjoy citizenship because someone turned the blind eye for her, basically for her application that was not could not qualify. And then we have the case of Carlos Bambo. Carlos Bambo went to Lisbon to play for Benfica as a football player, but apparently there was a problem, and he was criminally persecuted, and Benfica was unsure about what to do, and sent a letter to the administration telling them about what happened. And there was a revocation clause, so people that were granted citizenship as indigents could have the citizenship revoked if they would go back to their indigeneity modes of living, or if there was any breaking of the law. In Carlos Bambo's case, it's unclear if his citizenship was revoked, but it just shows us how even after being able to get citizenship, some people that live at the margins of citizenship itself, of the state itself, meaning the colonies in this case, they also can get their citizenship easily revoked, their rights easily revoked, or at least easier than it would be to revoke from others. Here, for instance, we see the difference in real life for people that would live as indigents. In general, in Angola and Mozambique, but also in other colonies, when you would work for specific companies, they would provide you with dwellings, they would provide you with accommodation. And if you worked for Diamang, the Companhia de Diamantes de Angola, you would be given different dwellings depending if you were a citizen or if you were an indigent, if you were someone that was assimilated or if you were someone that was not assimilated. If you were an indigent, that would be your dwelling. And if you were already assimilated, this would be your dwelling. So that was embedded into everyday life. That was embedded not only in the rights you'd have, in the possibility of going to school, but also in where you would be living. And this would reverberate in many different aspects of life. And I think that's why it's important for us to think about citizenship as a lived experience. Otherwise, we just fall into the denial of those very specific details that make livelihood so different. Sorry, this one. And now, how much time do we have left?
We have 45 minutes, so if you want.
Yeah, what time is it?
No, it's 7:15, so we'll go until 8, but we have Q&A.
Okay, so I'll be 10 minutes. Is that okay?
Yeah.
Okay, great. So, okay, great. Now I think that Macau will take us at least halfway through the story. Macau was such an important center for Portuguese colonialism back from the start until the very end, until the last night of Portuguese Empire. And when thinking about Macau, it's interesting to think about the different stages that Macau progressed in being a colony. Arnaldo Gonçalves says that Portugal's presence in Macau did not lead to the territory being considered a true colony, since it had not been taken by force from another sovereign power. Its occupation was legitimized through the tacit consent of imperial Chinese authorities in Canton. Then this changed, but the idea of Macau lying in between empire is something that is very clear in the way that we read law too. And this will become clear towards the end of this part. But thinking about Macau is thinking about the crossroads of the Portuguese Empire. Is thinking about the beginning and the end at the same time. Is thinking about what I call the prova real, so the confirmation method for race, citizenship, and rights in the Portuguese Empire. And the way that Macau was constructed legally, and I think that's something that we still notice today, and this is the first time I'm in Macau, so I'm finding it very interesting to notice the reverberations of this individuality, not only in the law that I know, but also in the real lives when you get into a bus and everything is translated into languages, and also socially and culturally, how interesting it is to be here. And I can say that now I understand a little bit more than I did before. So the first aspect to understand when we think about Macau from a legal point of view is that it tended to occupy a secondary place when compared to India, legally speaking. Macau, given its territory, and India, given its territory, they're both similar in the way that they were connected to Portugal. Both of them were not understood as colonies per se. They were understood in different times as a government, or as a state, or as a territory under Portuguese administration. So colony was not necessarily used overtly, was not used openly to classify India or Macau. And the connection between India and Macau, I think it is something still to be developed, but I think that something very interesting can come from this comparison. And the reason for it is because Macau and India, they're the only two remaining, they're the only two territories with remaining claims to Portuguese citizenship. If you were born in India before 1961, if I'm not mistaken, you can still claim Portuguese nationality. And Macau, still until their handover, depending on your heritage, you can also claim it. And that's not the reality when we look at Portuguese Africa. Since 1975, with the Denationalization Act, most claims to Portuguese nationality emerging, so coming from former Portuguese Africa, find a much more complex path when we compare to Macau and India. Interestingly, the connection between India and Macau to the United Kingdom, where I work, is very close. And I'll give you an example. I work at the University of Leicester. Leicester is the most diverse city in the United Kingdom when you're talking about nationality. And Leicester is the city in the United Kingdom with more Portuguese people. But the language they speak is not Portuguese. They speak a variety of languages coming from the Indian subcontinent. So most people that have Portuguese passports and live in Leicester, they were able to claim Portuguese nationality through the Indian route, as I call. So they're able to claim Portuguese nationality through going back to the origins in the former state of India, Estado da India, and then get Portuguese citizenship, which creates a very interesting terrain of research, because the research about Portuguese citizenship that we are developing in Leicester, and we're trying to even establish a legal clinic for people interested in claiming Portuguese citizenship through the Indian route in Leicester. They are inherently colonial. It's inherently colonial law. We do not have a lot of experts in colonial law. We're trying to change that. So if you're interested in pursuing any kind of degree, please do get in touch with me. The connection with Macau is also very interesting when it comes to the United Kingdom as a proxy, if we may. A lot of people came to the United Kingdom with a Portuguese passport connected to Macau. They were able to get to the United Kingdom despite people from Hong Kong not being able to. So when you have a Portuguese passport, before Brexit, if you had a Portuguese passport, you could freely move into the United Kingdom. But people from Hong Kong, despite being for a former colony from the kingdom, could not do that because British nationality overseas, which is the normal status granted to Hong Kongers with a connection to the UK, it does not allow you to have right of abode. So you cannot have that. You have a British passport, okay, British passport, but you cannot live in the United Kingdom. But people from Macau with a Portuguese passport could. And that is the last part of the presentation, where we'll go over that, and specifically the pressure that the Portuguese government and Macau were under during the transition period, during the handover by the British people, but the British government, sorry. So when I say that Macau was secondary to India, the only reason I say it is from a legal point of view, because from a sociological point of view, that's not the case at all. Macau is a very interesting case when you think about civil law, the application of civil law. And again, the connection with India appears. Macau and India both had codification of native costumes. So they had the codification of legal modes and costumes of locals. And they are both applied by the Portuguese administration. So, for instance, in India, the native code established even excommunication, which was from Hinduism, not from the Catholic Church, which is very interesting for a colonial power to be able to codify native customs and impose it onto them. So it's a very interesting case study. When you think about Macau, the codification was shorter, but it was nonetheless present. And whilst adoption in Portugal was illegal, adoption in Macau was legal during the Portuguese Empire. And that's one interesting point as well. That is a bold claim, the existence of Macau in tandem with Hong Kong. But I hope that this makes sense by the end. So I'll leave it here a little bit longer, and we'll go back to this by the end. What I think is most interesting about the Macanese case is what I call the procedure of citizenship justification, and that is a translation of processo de justificação de nacionalidade, which was a procedure that would be engaged once someone was suspected of not being Macanese. So if you're suspected of not being Macanese, the government would engage in a procedure to make you prove that you were connected to Macau. So this would go over the courts, so you'd be summoned to go to the courts. I think I have it bigger here. You would be summoned to go to the courts. This is from 1924. So you'll be summoned to come to the courts to prove that you had a true connection with Macau. I didn't translate it all, but it says, the judge of the Judicial District of Macau, in the procedure of justification in which the respondent, Chi Chong, citing the interested to come forward to prove his quality of Portuguese citizen by the fact that he was born in Macau on the 7th of the first moon of the 11th year of Quosui, 22 January 1885. So this is so far absent from the legal literature. This is something that I was able to find in the diplomatic archives in Lisbon by chance, by looking at folders on slavery and Portuguese overseas. I came across a folder where a half page of those justification processes were printed. And for me, they are interesting in many aspects, but one specific aspect that they actually are very strong is in how they support the claim that Portuguese citizenship was ruled through a racial means. How Portuguese citizenship was established with a racial principle, as embedding principle of who should and who should not have rights in the empire. There are many cases similar to that one. I was able to locate around 4 or 5, but the Gazette of Macau has many of them, especially from the 1920s. And those people would generally, but not always, be connected to Hong Kong. So there was this suspicion that people from Hong Kong would be claiming to have been born in Macau in order to be Portuguese. I'm not too sure how the results would go, because the results, they were not published. Either the person would attend and therefore prove their citizenship, so prove that they were connected to Macau, or go and then have it rejected, but the results would not be, the decision would not be published, just the summoning of the person to the courts. And I find that it's one of the most interesting points about, there are many, and I wish I would be able to talk about them more, but I think that it was necessary to cover the first two parts, otherwise this would not make sense now. So after all, Macanese people were never indigenes. Indigeneity was never applied to Macau. People from Macau were always, legally speaking, fully fledged citizens. So why was this procedure engaged? Why was this procedure engaged in a way that would use ethnic and language traits as means to suspect someone was not born here? So I think that this is a confirmation of the bias, the racial bias that was embedded in the law, because not only Macau was never an indigeneity colony, it could never have been. All the laws denied it throughout the centuries. So why to have such a procedure like this one? And this brings us, how many minutes do I have?
We still have half an hour to 8.
Half an hour, okay. So this brings us to...
Including Q&A, of course.
Yeah, exactly. I was a little bit cautious about the content, so I wanted to give a lot of time to Q&A.
Okay.
So yeah, I think you'll finish in 2 or 3 more slides. Yes. The case of Macau being the last Portuguese colony also reverberated internationally. So during the period a little bit before the handover, there was an exchange of documents between the Portuguese and the British government, where the British government basically asked Portugal not to give Macau, the Macanese community, citizenship, because it would generate problems to the British people, the British government, sorry, because they were not willing to do so for Hong Kong. So the papers that they had been found by a journalist in continental China, but never being published as a whole. And the papers, they established that the British government was trying to pressure Macau, the Portuguese government, in relation to Macau, not to grant citizenship to the population, to the community here. For instance, parts like, why your letter do not seem to meet our worries, we may come under some pressure because the position of Portuguese nationals in Macau to allow freer access to the United Kingdom, to Hong Kongers BDCs than it is presently. What it wanted to say is that they were afraid that if Macau people would be granted Portuguese citizenship and Hong Kong people would not be granted British citizenship, this would create animosity between Hong Kong and the Kingdom, as it did. Really should not drift into a position in which the unintended consequences, I think that's the focus, of Portuguese accession is the potential immigration of large numbers from Macau. This was confidential. This has only been declassified a couple of years ago. The letter is 2 pages. I didn't put the other page there, but the letter, basically, the tone is trying to avoid Macanese people from getting Portuguese citizenship, from getting a Portuguese passport. So Macau, for me, is a global citizenship center. It connects not only with Portuguese Empire, but also how it was possible to access the European Union, how it connects to China, how it will maybe in the future connect to the BRICS. I was just at the airport. I think I flew, but no, I took a boat from Hong Kong here, and some people from Brazil are able now to use the e-gates to enter. So I think that Macau provides us a multi-layered territory for us to understand the idea of citizenship, not only to understand it, but to see it through the lives of people that have been here for many, many centuries. And here at the end, I just put the cover of the book that is coming out later this year. If you're interested in getting the newsletter from the press, you can scan the QR code. And also my profile, if you're interested in getting in touch with me, you can scan it and you directly to my academic profile, where you can have access to my email, my telephone number from the university as well. I think that's it. Thank you very much.
Thank you, Marcel. Very insightful, very deep research. I learned a lot, and I hope to read the book. It's really interesting, and I hope, hopefully, to get a book to one of our libraries as well. It will be very interesting. I hope to take one of the copies also to Mozambique, because I'm from Mozambique as well. I would like to hopefully put in our library in my alma mater at University Eduardo Mondlane. That will be really nice. I know that there is sometimes a big gap in this research, specifically on this topic, on colonial citizenship. So before I have some curiosities, but probably I will open the floor first to the audience and see if we have some questions or commentaries from the audience.
Thank you very much, moderator, and thank you very much, Dr. Marcelo, for really these interesting presentations. It gives the desire to read your book. So many informations, indeed. My question is not that complicated. First, when you talk about the Portuguese colonial system, we know Portugal was not the only one in the African part as a colonial master. So how do you relate the practice or this colonialism practice of Portugal with the French approach to those colonies in Africa? And also we have UK as well, right? So if you can tell me what's the main distinctions, similarity or differences between those approaches, and precisely with regard to this question of citizenship. And my second, it's more a comment, because I saw in your presentation you mentioned many times Guinea. I know there is this way of understanding this name depending if you are from Portuguese or French-speaking country. If you ask me, I'm from Guinea, but it's not the same Guinea as Guinea-Bissau. Usually, but I don't know if in the future that might create a confusion, because of course, people coming from Portuguese-speaking country, they know Guinea is Guinea-Bissau. People coming from French-speaking country, Guinea is Guinea-Conakry, right? Yeah. So, but your book is for, it could be for any of those. So, whether it will be important to bring this clarity in which Guinea you are referring to, because your audience, your reader might be coming from a different type of Guinea. Okay, and yeah, those are the two things I want to mention, to leave the floor to others as well. I may come later again if there's still room for asking questions.
Thank you. Well, if we don't have any media question, we can... Okay, we have one on the back, sorry.
I don't know if you want to answer him first or just get all the questions like at once.
Yeah, let's go one by one, if that's okay. So I'll go the other way around. So I normally talk about Portuguese, former Portuguese Guinea. I don't talk about Guinea-Bissau, because Guinea-Bissau is an idea that only became a reality later, after the colonialism. So that's why I tend to avoid Guinea-Bissau, because I'm afraid that people that will read it will think anachronically, will think, what's happening here? Yes. So I tend to use the name either former Portuguese Guinea or ex-Portuguese Guinea to make sense of the territory I'm talking about. The reason I mentioned just Guinea here today is just for the sake of making it more dynamic, but definitely, I always try to make it clear that I'm talking about former Portuguese Guinea, currently Guinea-Bissau. So yes, thank you very much. I appreciate it. When you're thinking about citizenship and empire, the Portuguese and the French, they were the two ones that actively engaged more in assimilation, but not in indigeneity. Other empires also applied indigeneity. The Italian Empire applied it. The Spanish Empire in Africa, in Guinea Equatorial, applied it too. So whilst the idea of assimilation was more connected in a comparative point of view to the Portuguese and the French empires, the idea of indigeneity was almost across the board. So most empires with territories in Africa, and Keisha Fikes, she says that indigeneity was a synonym for absolute blackness. So if you'd be legally understood as being absolutely black, you'd be an indigene. And this idea was present in other empires too, like Spain, like I mentioned, Italy, France, Portugal, Belgium, definitely. They applied indigeneity, or the idea of this, to castes, almost, to classes of citizenship, of belonging in their empires. So the interesting thing about the UK is that they tended to have a more association approach to empire. Sometimes they would create alliances with local chieftaincies and rule indirectly. So an indirect rule rather than a direct imposition, like tended to be the case of Portugal and France. So to reply to the question, assimilation was mainly seen, like legally, in the Portuguese and the French Empire. And there's an amazing book called Children of Empire from Emmanuelle Saada. She's a professor at Columbia University, and she basically talks about assimilation and citizenship through the lens of children of mixed race couples. It's a very interesting book. She's been writing profusely on the topic. So for the ones interested in assimilation, citizenship, and empire from a French perspective, I would definitely recommend Emmanuelle Saada. She's a very good scholar. Yeah.
And if I can interject, actually I wanted to ask related to mixed children. Mm-hmm. How was it, their situation?
So the law was very patriarchal. So for instance, and this has two dimensions, the marriage dimension and the children dimension, so the offspring dimension. So if you were a woman and you wanted to assimilate, you could do by your own right, but you could also rely on your husband to assimilate. So if your husband was assimilated, you could become assimilated automatically. But the other way around could not happen. If a woman was assimilated, the husband would not get assimilated. They would not get citizenship. And children, it started not very clearly, but towards the end, especially in the late statutory period, it was clear that the father played an important, almost fundamental role in allowing children to assimilate. During a period, it was only necessary for the father to be assimilated for the children to get citizenship, like automatically almost after registration. But in the later periods, the father not only had to be assimilated, but also play a central role in the education of the child, and assimilation would only count until the age of 18. So it became starker as the time progressed. So in the case of mixed race children, if the father was white, then definitely the child could get citizenship. If the father was not white, the question was a little bit murkier, a little bit more difficult.
Thank you very much for your talk, Professor Loureiro. I would like to echo the comment that this is in fact very important research, if for no other reason that it does provide a more concrete rebuttal to the very common myth of lusotropicalism and various myths of assimilation that come with it. On my part, I do have 3 questions that I would like to ask. Firstly, you presented a quote about Macau's status as a colony, and this is like a very common debate whether or not Macau was or wasn't a colony. I would like to know whether or not you have an input on the matter. Of course, I understand that the scope of your research is not specifically dedicated to Macau, but I would like to know if you have anything to say about that. If for no other reason, because the quote that you posit does not take into account that the transition for colonial governorship came with the expulsion of Chinese court officials, the burning down of the customs house, all those kinds of violent colonial endeavors that then characterize the next 100 years of Macau's history. Furthermore, I was particularly captivated by this idea of citizenship confirmation here in Macau. To this point, I would like to understand a bit more the racial component of it all, because you use the word Macanese, and maybe I would like to get a clarification. In English, of course, when we say Macanese, it does not presuppose that the person is mixed race in the same way that in Portuguese we have. So, I would like to have a bit of a confirmation on that dynamic, whether or not the confirmation was also to ascertain whether or not the person was mixed race, because knowing the history of Macau, not many people try to apply for that Portuguese citizenship because historically there had been access to the Portuguese language, but also that mixed race background traditionally. But I would like to know your further thoughts on that. And finally, I would just like to know your thoughts on distinct differences between attribution of citizenship between Macau and Hong Kong, since those are two territories that are often contrasted with one another. Of course, there's always the language aspect, that access to Portuguese language was historically restricted in Macau, whereas in Hong Kong it was much more widely circulated as a way to create a different consciousness of Hong Kong identity. So I would just like to get a bit more of your thoughts on this contrast between citizenship, indigeneity between Macau and Hong Kong. Thank you very much.
Thank you. It's very interesting you mentioned lusotropicalism. When I was writing the first draft, I had a whole chapter on lusotropicalism, because for me it was one of the main ideas that I wanted to refute, because I'm half Brazilian, and coming from Brazil is I think it's the place where lusotropicalism basically was not only created but used as the case for lusotropicalism, Brazil. And having lived in Brazil for many years, like most of my life to be honest, and having access to favelas, and the book starts with the first time I saw someone pick food from litter bins. So the first time I saw someone actually go for food in the trash can. And how this affected me, having lived in Brazil and seeing this almost every day since I was 6, and started realizing that people live different lives. This marked me in a way that lusotropicalism could never revoke. So I think it's very interesting that you mentioned lusotropicalism, because it was the first idea that I wanted to refute, and indeed it did not happen. And anyone that go to Brazil or any of the former Portuguese colonies in Africa, I think would be very able to understand that this idea of lusotropicalism was just to sell. It was a marketing strategy more than anything. So I think I will start first with the status of Macau. It is a contentious notion. In the book that I took the quote from, there's 2 pages describing how the very different periods and how it developed from one thing, an entrepôt commercial, into something else, into establishment, into a government, into a territory under Portuguese administration, and all the necessary shifts and nuance of language that were almost mandatory for this to work. Because Macau was a very special case, and I think it's one of the most special cases in terms of the legal world to understand. And one of the reasons is especially that what was the status? How was this establishment legally recognized and able to survive? But lately, in the last periods of Portuguese the Portuguese Empire, Macau started to be termed as territory under Portuguese administration. And I think that that gives us an answer, but also a lot of space for doubt, because when we think about colonies, we tend to think about settlement colonies, so colonies of exploitation, like Brazil, Jamaica, for instance. And when we think about provinces or states, like the state of India, we tend to think about other means of socio-economic organization. So if you're asking from a socio-economic point of view, if I believe Macau was a colony, my answer is no. But if you ask from a political and constitutional point of view, if Macau was a colony, my answer is definitely yes. When it comes to the issue of the Macanese, like being mixed race, if that has the same idea, the same nuance as it has in Portuguese, I don't think we have that in English, that nuance that you mentioned. But what the justification procedures were trying to establish was a genuine connection to Macau, either through territory, because back in the period, birth in Portuguese territory would give you Portuguese nationality automatically, but not only birth, but also origin. So if you had Portuguese origins but were born in Hong Kong, you would still be able to be officially recognized as someone attached to the territory of Macau, therefore granting you Portuguese citizenship. So the idea was not necessarily to ascertain if someone was mixed race or not, but to ascertain if someone had a claim to Portuguese citizenship, either through heritage, also including Macau's heritage, or a territorial birth in Macau. So if the person was from Hong Kong and the mother came to Hong Kong, to Macau and gave birth, the person would be Portuguese. So it was not necessarily a racial, only racial issue, but race played a role, ethnicity, race and language played a role in suspecting someone was not from here, in starting the procedure. So I suspect you're not from here because of your traits, because of your mode of speaking, etc., etc. So this was the start of the procedure that then you'd have to refute through the courts. I think that was, oh no, the attribution of citizenship in Hong Kong and in Macau. It's very interesting that you mentioned the word attribution, because in Portuguese law, as in French law, if I'm not mistaken too, we have two modes of acquiring citizenship, of gaining citizenship. One is attribution and the other is acquisition. In Portuguese law, when you're thinking about attribution, we are thinking about something you always had. So I have Portuguese citizenship through my father. I only had to engage in it like after my birth, so after I was born, so I was not registered right away in the Portuguese consulate. But once I was, that would retroact to the date of my birth. That means that I was attributed Portuguese nationality. I was born Portuguese, even though I lacked a certificate saying so. So that's what attribution means. So for Macanese people, for people connected to the territory of Macau, nationality was attributed. It's automatic. You have right to it from the minute you were born, even though only later in life you have it recognized officially. That idea of belonging has always been in you, so we've been attributed it. The government attributed you a registration, formally. But acquisition is something different. When you acquire citizenship, you acquire it by different means, for instance, naturalization, or by marriage, or through adoption. So that means that you are not organically, and that's the word I use in the book, you're not organically connected to that nation, but to become connected later through other means, marriage, adoption, whatever, residence. So attribution has always been the means of, the way of giving citizenship for people related to the territory of Macau, but in Hong Kong it's different. British citizenship only started to be a legal idea after citizenship had been spread across Europe. British citizenship only started to become necessary when the white dominions, so Canada, South Africa, Australia, started to raise against people from India and other territories of Portuguese Empire moving there. So Canada issued a law basically creating a national citizenship for Canada that would prevent others from moving into Canada as a British colony, and that started a process that made all of the other many of the other white settlement colonies in the British Empire, like Australia and New Zealand, also create local citizenship laws that would prevent people from coming from other parts of the empire. Because in the British Empire, if you were subject of the monarch, you could move anywhere. And then it was only after that that British citizenship, per se legally, was created. So if we are thinking about this idea of British citizenship, people from Hong Kong had always been British, but with the handover, and especially thinking about the size of the community of people in Hong Kong, the Brits thought that it would be necessary to foreclose that possibility, as we've seen in the papers from FCO. So the way that people from Hong Kong and people from Macau are connected to their motherlands, if you wish, is completely different. Macau was always considered part, to a certain extent, under administration or as a colony, depending on the period we are talking about in history, but always a part of the Portuguese territory. Hong Kong, not necessarily. Hong Kong, at least towards the very end, was completely refuted and rebuked and not necessarily granted the same rights as people from Macau were granted by the former colonial power masters. Yeah, I think that's it for the acquisition question. Thank you very much for the question. They're very good.
Okay, thank you very much. I have two questions that I really would like to ask. Then we'll pass to Francisco.
Sorry, just two quick queries. Congratulations, it's a fascinating presentation that you did. I have two simple queries. Sorry, I don't know exactly the terms, but I will be oversimplistic. You mentioned on your initial presentation, initial part, that in 1602, probably due to when Portugal and Spain was colonized or dominated by Spain, there was the start of this understanding of nationality or citizenship through soil or through sanguinis. You mentioned that that's a proof that was never only through soil. So my question is, when did that stop? The two-way approach to the acquiring a citizenship. So that's a very simple query. I would like to, if possible, to have it clarified. And the second thing is just a comment that just will say, you did not mention Brazil, except for this last answer. It will be also fascinating, and probably that's the invitation for a second talk, because the colonial status of Brazil is so specific, in particular, when Brazil was the head of the Portuguese kingdom. So when the king moved over there, lived over there. So what are the major consequences, or what is the outcome that you can highlight by this fact of the kingdom to be in Rio de Janeiro instead of Lisbon, that changed the perception of the colonial citizenship? Is basically that. But congratulations on your presentation.
Thank you.
And maybe since we are a bit running short on time, maybe I can ask the two questions and you can answer all of them together. Okay. The question that I would like to answer relates to what specifically precipitated this colonial act of the 1930s. You said they were in Africa and other places for around 400 years or more. And the other periods, the previous periods, as you say, they took longer. But then from 1920 something, 1930, it seems there was something happened there that precipitated these major changes that had huge impact on colonial citizenship. I would like to understand the context. And related to this, we know that from the 1960s, then the independence movements started, but based on my lessons from history, I remembered studying that some of these student movements that later engaged in independence struggle started in the 1930s, 40s. So although the independence struggle started in the 1960s, but the movement already started in 1930s. I was just wondering whether this had any connection at all.
So I will start with the Iberian Union and then go in order. Thank you. Yes, when we're thinking about the start of Portuguese citizenship law history, we tend to go first to the Philippine ordinances and have a look and say, yeah, that's it. But when we go back a couple years, a couple decades, we understand that it was actually during the Iberian Union that citizenship started in Portugal. And the way that it was formulated was through different, it was a mixed jus soli and jus sanguinis approach that would balance things out, basically leaning more towards jus soli at the very beginning. The question is very interesting because at the debates parlamentares, so the debates in the Portuguese Parliament, it is claimed that, and it was only in the 20th century, it was only the 20th century that Portugal goes back to jus sanguinis, when in reality it has never been jus sanguinis. And in Parliament, the argument used by one of the MPs, by one of the deputies, is that Portugal is going back to the same way that other nations with the same historic roots have. Basically saying we are going back to jus sanguinis, just like other empires are going back. Just like other empires, they are also like us have been using. And that's not true. Other empires, like during the Napoleonic period, for instance, jus soli was the means of transmission of citizenship in France. So this idea that European empires would give citizenship through blood is a very new conjecture. It's a very new notion. It's a very new concept. Before the 20th century, before the 1900s, that was not the case whatsoever. The United Kingdom only transitioned to jus soli way later than others, and the Portuguese did so too, just in the 20th century. So this idea, this mythology of Portugueseness transmitting through blood, it's a lie. Portugal has always been, to a certain extent, a country that allowed to a certain degree of assimilation. Many of the Portuguese consuls in Africa were from the state of India. In the book, there is a passage where I talk about the lack of invitation. So a consul, a diplomat in Tanganyika, was not invited to the birthday celebration of George II, I think, and he wrote to the British government asking if the reason for him not being invited, he was the only diplomat not to have been invited, was because he was a son of the state of India. So in the Portuguese Empire, there was some possible movement if you were assimilated, which is interesting to think about how we've been thinking about Portuguese citizenship as being something that flows through blood. That's not been the reality, at least not in our Portuguese history. Brazil is a very interesting case. Brazil being a united kingdom to Portugal and the Algarves. The thing with Brazil, the complexity of Brazil is also very interesting because it shaped the way that colonial citizenship was thought, because it was Peter II of Brazil that wrote the constitution. And this constitution was delivered to Portugal by a British merchant, by a British representative. So the history of Portugal and the history of Brazil and the history of the United Kingdom, they're very interconnected, especially in the colonial periods. That's why I think that Macau is also very important. Entrepot is a very important point in the world to understand the global history of Portugal, because it connects also, just like Brazil, with the UK, being so close connection. And so I think Brazil is definitely an interesting case. it's part of the book too. I don't go on it extensively, but it's part of the book, especially in relation to Peter II of Brazil, that then became Peter V of Portugal. So yeah, the book explores it a little bit, and the idea is that Brazil and Portugal at that period in time had sibling nationality clauses. They were the same, copy-paste nationality clauses, and they were the beginning of the constitutional establishment of nationality. Nationality was established in the Portuguese constitution for many decades, and then migrated to the civil code, and then to a specific nationality law like we have today. But yeah, it's intrinsically connected. Brazil is intrinsically connected with the history of Portuguese nationality law too. Thank you very much. The questions were very, very interesting. Now the most complicated question is the last one, but I will try. I will try to be as clear as I can. But so why the 1930s? So colonially speaking, since at least the 1910s, so the first decade of the 20th century, with the Republic, so when the monarchy was abolished, some movements started to happen in colonial terms, and with fascism, with Portuguese fascism, with the Ditadura Nacional, and the rise of Salazar to power, the idea of assimilation became a little bit contentious. So people were a little bit afraid of assimilation, especially in Mozambique. Mozambique was the place, one of the former colonies with more educated people of color, with more educated people that were from Mozambique. And they even have very notorious newspapers that would claim citizenship for people of color. They would claim citizenship for the native communities. So during the 1930s, there is this notion that citizenship for non-whites should be something feared, because if they have citizenship, they could get into the system and start to ask for changes. And interestingly, it was also during this period that provincial law started to regulate citizenship. And the reason why provincial law started to regulate citizenship was to make it harder to get, because the procedure for citizenship, to get citizenship in Mozambique was completely different from the one of Guinea, that was not very much the same to the one of Timor. So they would encompass the same requirements, but for instance, in Mozambique, you'd have to go to the courts, and in Guinea, you'd have to go, Portuguese Guinea, you'd have to go to an administrative office. So they would differ from colony to colony, and it was very much so to make it more difficult. And think about decolonization in the 1960s. The 1930s were, for me, definitely the years where this start to become more palpable. They start to be able to see it becoming a reality. And I think that the only way that I can translate this in more practical terms is by using the case of Portuguese Guinea again, where Portuguese control was not established. The dominance of the Portuguese was not established until the 1930s. And the way that they were able to do it was by forming alliances with local communities. And those communities then started to create animosity with the other local communities. So I'm not too sure if that was the origin of all of that, but at the same time, I do believe that there was already a degree of political discontent. The people were not happy with the situation they were living in. And I think that the 1930s are necessarily this fundamental period for us to start understanding it, something that only erupted with force in the 1960s. So I think that that period between the 30s and 60s, it's a very interesting period for us to understand not only the outcome, but also the process of independence and decolonization that led to the end of empire.
Thank you very much. Very deep indeed. It was a very enlightening talk. I enjoyed and I learned much. I'm sure the audience as well. Thank you very much.
Thank you, guys. Thank you, everybody.
Hopefully in the future we'll have other opportunities to go deeper into some other topics. And I would like also to ask to thank the audience, Rui Cunha Foundation, for hosting us once more. and to organize this amazing event together with the Faculty of Business and Law of the University of St. Joseph. So hopefully we'll see each other very soon. Next week we will have one more event, and this time is our master talk, is our law and tech talk. We will be talking about harmonization of data protection standards. So you are once again welcome to share some more thoughts for all of you. And for you, I don't know when you return to the UK, but while we're in Macau, I hope you continue to enjoy, and it's been a pleasure.
Mine. Oh, mine. Thank you. Thank you very much.
I think we can take it.